be seated.
Good afternoon, Your Honor. It's nice to see you again. It's been a while. Bill Hazeltine, O'Sullivan, Nimiroff, Brown, Hill, on behalf of the debtor, Glenwood Cavern Holdings. I'd like to introduce my co-counsel, Mike Pankow of Brownstein, Hyatt, Farber, and Schreck, and the company CRO, Paul Maniscalco of Macro Restructuring Group, excuse me. Your Honor, I'm going to make a few opening remarks. Mr. Pankow will go through it in much more detail. But as Your Honor probably saw from the pleadings, we're here because of a very tragic accident I should step back. Glenwood operates and owns and operates an amusement park in Glenwood, Colorado. And the tragic accident resulted in the loss of a young girl's life. The plaintiffs got a huge judgment against Glenwood that they just can't pay. And over the last, we got involved in this case in early December, maybe late November, and we have been ready to file on several occasions. In the meantime, Mr. Pankow and Mr. Maniscalco have been in discussions with the plaintiff's counsel about possible settlement. We received numerous standstill agreements to stop execution. Eventually, we ended up filing on Monday. And part of the reason I bring that up is to express my heartfelt thanks to the U.S. Trustee's Office for the on again, off again, on again, and off again. They've been very, very cooperative and have made this process a lot easier than it could have been. And I'd also like to thank the court. We've made numerous calls to the court about a possible bankruptcy filing. And so they've been very cooperative as well. Your Honor, I just want to mention service of all the petition and the first day pleadings. Epic Restructuring is our claims and noticing agent. I have a certificate of service here attesting to the service of everything. I don't know if Your Honor would like to see a copy.
Certainly. Thank you.
And they assured me it's all been served according to the court's rules.
Very good.
And with that, I will turn the podium over to Mr. Pankow.
Thank you.
Good afternoon, Your Honor, and thank you. It's a privilege to be in this court. I also would like to second Mr. Hazeltine's expression of gratitude to the United States trustee. They were extraordinarily responsive and extraordinarily patient, through the fits and starts of this, and have been a pleasure to work with. Appreciate them. So I think we're here by consent. We may have one issue, a couple issues, floating language, and I don't want to get out in front of anybody on that, but I think we're proceeding by consent. So I'll just give a quick overview. I think the court has probably heard a little bit and probably has read the papers. The debtor before the court is Glenwood Cavern Holdings, LLC. It owns and operates an amusement park in the town of Glenwood Springs, Colorado, which is on the western slope on the other side of the Rocky Mountains from Denver. If you're driving from Vail to Aspen, you'll drive through Glenwood Springs. It's a town of 10,000 people. It is the only mountaintop amusement park in the USA. One accesses the park via gondola. The park started 25 years ago as tours of caves located in the mountains and started adding rides about 20 years ago. Currently, the park offers cave tours, 6 rides, and other attractions. For some order of magnitude, the park attracts attendance plus or minus of about 200,000 patrons a year. Revenue is about 16 million plus or minus, and the assets are unique. It's up on top of a mountain, side of a mountain. There are roller coasters up on with a mountain view. I have personally never been there, but I have seen pictures, and it is unusual. The park's employment varies seasonally. During the summer months, it employs about 250 people. It's not what you would call a destination park like a Six Flags or a Disney, but it is an important attraction in a small town. That does generate does depend in significant part on tourism. The corporate structure is fairly simple. This is an operational entity despite the name Holdings in it. And it is 100% owned by another entity called GCAP Holdco LLC. That in turn is owned in part by some private equity investors and 17% interest retained by the founder of the park. I'll just mention one outside director because I think it gives a point of comparison for the park. His name is Jeff Clark. He doesn't have a financial investment in the park, as I recall. He happens to run the amusement park on the Santa Monica Pier in Los Angeles. So, just adds a little color to that. The debt structure here is very simple. There's a secured lender, Community Banks of Colorado, outstanding balance of just under $13 million, series of loans secured by a deed of trust, which is the Colorado equivalent of a mortgage. The maturities start in 2029. There's a small amount of trade debt, and as Mr. Hazeltine mentioned, the largest debt, and the reason we're here today is a large judgment resulting from from this tragic accident.
Let me ask a question because I'm curious.
Mm-hmm.
So the bank has a mortgage. Does the park? I mean, the park owns the park, but it doesn't own the mountain, does it? How does that work?
Oh, it owns real estate that happens to be located on the mountain.
Okay,
on the mountain.
so it does have the real estate that the park is owned on. I mean, the park is on. It owns.
Right.
Got it.
Right. So the reason we're here ultimately is this tragic accident and the consequences from that. In September 2021, a little girl died on one of the park's rides, and it'd be presumptuous of me to speak of the effect on her family. I'll just have to touch briefly on the park's response. The park shut down that ride for 2 years, redesigned it, has reviewed, revamped safety processes, engaged gold standard outside training individuals, and they have trained their supervisors who then audit and monitor, and it is a very rigorous training and auditing program. In addition, one of the other rides that had been manufactured by the same manufacturer, they just shut it down permanently. From these lessons that have been learned, the park has thought it important to reach out to the rest of the industry and has reached out, engaged in trade groups, and made presentations to other amusement parks on what can go wrong, how to prevent it from going wrong, and hopefully somewhere that will help someone. On a parallel path, there's wrongful death litigation that proceeded through the Colorado state courts. Trial in September of this year, a verdict came back, order of magnitude $100 million. So here we must obviously deal with the financial impacts. The underlying CGL insurance policy was only $5 million. And that actually includes a primary and a first level excess. So obviously the judgment far exceeds the assurance available. After the judgment was entered, the company retained Mr. Maniscalco as chief restructuring officer and counsel. And the plaintiff at one point started to execute on the judgment, but then conversation started, we reached out and tried to work this out over the last several weeks. In the process, we provided comprehensive financial information to the plaintiff, available to answer questions as we could. There was back and forth, and in that there was a series of standstill agreements. The last one expired on Monday, which is why we ended up filing on Monday. Moving forward in this Chapter 11 case, Your Honor, I should point out this is not a pre-pack. Our planning and efforts and the efforts of the company and the board have been focused primarily on finding a solution out of court that would preserve the park and would be be satisfactory to the plaintiff. So the debtor will need to take a little bit of time to use the automatic stay, a breathing spell here, and determine the best exit strategy, which may be a going concern sale. On a parallel path, the state court litigation technically will now be stayed. I would anticipate probably filing a motion to modify the stay to permit appellate proceedings, to go on in that case. I haven't discussed that with plaintiff's counsel yet, but that's probably something we'll propose. And we could have a plan with a sale, potentially with a claims reserve, to sort that out. Now we continue, and we may also continue to negotiate with the plaintiffs. Now, of course, in a slightly different context than we were outside of court. The immediate needs of this debtor, I think, are fairly straightforward. It does not need DIP financing. Instead of revolving the facility, the lending here generally, because there's a lot of seasonality in the cash, the company would just hold a large cash balance from the high months, and then it would decline over time in the low months. So at the end of summer, cash is high, starts to decline. The trough bottoms out probably April, May, depending on the weather and everything, other things affecting Colorado, and then it starts to build back up again. So right now we're sitting on approximately $3 million cash. And for the next few months, there will be a cash deficit, with seasonality and, costs of administration. So while I mentioned we do not need a DIP financing, we do need cash collateral, and in that regard, we are proceeding by consent. We'll also need to ask the court for permission to make our payroll. The payroll cycle happened to end Sunday night, just before our petition, and if the court permits it, we will fund payroll tomorrow and issue checks on Friday. And then we have other matters such as insurance to address. So we can jump into the specific motions if you'd like, Your Honor. And we have shared these with the bank and with the United States trustee, and have received their comments. And before I jump into specific moments, I would offer into evidence the declaration of Paul Maniscalco, which sits at docket number 10.
Yes, let me ask, are there any objections to Mr. Maniscalco's, I'll get it, Maniscalco?
Yes, ma'am.
Thank you. His declaration coming into evidence.
Thank you. So we can start just with perhaps docket number 3, the retention to obtain, or the application to retain EPIC as claims and noticing agent pursuant to 28 U.S.C. Section 156C. We received informal comments to the form of order from the United States trustee, and we have a red line. I think Mr. Hazeltine, it has been circulated among, and perhaps we should hand one to the court. If you don't mind.
Your Honor, may I approach? I've got one filled. I think we're just on EPIC right now.
Thank you.
The only change there is, as I recall, is a change to the preamble of the order.
Does anyone wish to be heard with respect to the application to employ EPIC? I hear no one. I've reviewed it. I see the change. It's appropriate in this jurisdiction, and I will approve it.
Thank you. Next, at docket number 4, what I refer to as the matrix redaction motion, requesting to redact personally identifiable information from the creditor matrix. And there were comments to that order as well. And they are of a similar nature, as I recall.
Okay.
And I'm happy to answer that.
Which way? I'm sorry. PII.
If I may approach you.
You may. Thank you. Does anyone wish to be heard with respect to the redaction motion? Okay, I hear no one. I reviewed it prior to the hearing. I see the changes that have been made at the request of the Office of the United States Trustee. The changes are appropriate, and I will approve it as revised.
Thank you. Next, and I can just follow the docket numbers for now, the motion regarding, or proposed motion at docket number 5 regarding insurance.
Yes.
Oh. And in this respect, Your Honor, the debtor maintains the normal and appropriate assurance that the court might expect to see. For property insurance, there are 2 twists. One is that there's a premium financing so that there's a monthly payment shared for efficiency, among various entities. Number 1, and number 2, there's a brokerage fee that is associated with that. That is part of the premium payment. We would request permission to continue with payments of insurance pursuant to that program, and of course any other insurance that would need to be paid.
Does anyone wish to be heard with respect to the insurance motion? I hear no one. This is part of the shared services arrangement, correct, or no?
Broadly speaking, this insurance program, and I've seen it, for instance, where multifamily, or things are under common management. There are companies otherwise unrelated that happen to be owned, have common ownership of the private equity fund, pitch their insurance together in order to save costs. So we get a lower overall quote, and then the allocation to this debtor comes from the carrier. It's part of their quote.
Oh, okay, so this allocation is not an internal allocation. It's from the carrier based on whatever the carrier bases a premium on.
Precisely.
Okay. Okay. I think that was the only question that I had. Are there any changes to this form of order?
Yes, there were some corrections in the figures, and there is a provision inserted, I believe, at the request of the United States Trustee that the debtor will provide prior notice to the U.S. Trustee of changes.
Okay. Is there a red line that I can see of that?
If you don't mind.
Thank you. I got the cash management one.
I'm sorry.
No, it's okay.
We're still talking about insurance.
Insurance, yeah.
May I approach?
You may. Thank you. Okay, so I see the cap has been changed and reduced on the interim basis. Okay. And did y'all get a final hearing date from Ms. Johnson?
Yes.
I think so.
Your Honor, I understand it's March 11th. I don't.
Yes, March 11th at 2 o'clock. Okay, so that can be inserted in your forms of order. Okay. Okay, I've reviewed this. I see the changes made at the request of the Office of the United States Trustee. The debtor obviously needs to continue with its insurance in place. And I will approve this on an interim basis as necessary to avoid immediate and irreparable harm.
Thank you. Next, I would proceed to docket number 6, motion regarding utilities.
Utilities, yes.
And in that respect, Your Honor, the debtor has been current in paying its utilities as generally it has been in paying trade debt, as a rule. What we are proposing in the utilities motion is a deposit in the amount of 2 weeks. And as I mentioned, they've been current on the bills. There had been some back and forth about where to place the deposit. And the U.S. trustee had requested that the deposit be made at a bank that had signed the UDA, which our current bank and our current lender has not.
Okay.
And that's an issue for cash management, which we're coming to. And I think the resolution here, which we've come to shortly before the hearing, is that though it's only about $12,000 of utility deposits, the direction of where that's deposited is subject to the cash management resolution. So for now, they will be deposited at our existing bank, Community Bank of Colorado, subject to further proceedings.
Okay. Very good.
Your Honor, may I approach with a black one?
You may. Thank you.
Next on my list, Your Honor, at docket 7 is the cash management motion. And generally speaking, Your Honor, the debtor operates with 4 accounts. There's its general operating account where most of the activity is. Into that operating account, the debtor receives its revenues, credit card remittances, and it also pays expenses out of that account. It's trades and other expenses. Then there's a separate payroll account. That payroll account is administered by a third party, Paycom Serve, and Paycom issues checks out of the payroll account, to employees. Then there are 2 money market accounts, a money market account and then a reserve money market account. Those are kept separate because of the size of the balance, so that the size, if somebody hacked into the operating account, for instance, they wouldn't get all the money. So that money, there's about $2.4 million in that account right now. And what we're asking, Your Honor, is to continue with those existing bank accounts. There are reasons for that we would urge the court. We understand the U.S. trustee's position because we need to ask a waiver of Section 345. The resolution for today is that the U.S. trustee has asked that we insert language into the court order that says we'll we'll have 30 days to comply with Section 345, absent further of the court or agreement with the United States trustee. Now, I think there might be one or two open language issues on the order, or are we finished on that exact order?
Your Honor, Bill Hazeltine. My good friend, Mr. Waxman, sent me comments to this order like at 2:25.
Okay.
And I had them printed, but apparently it doesn't. The black line doesn't show up. So I can hand Your Honor a copy of the black line that we did, and then the order that I received from Mr. Waxman, but I don't know what was changed in it.
Okay, well, let me see what we have.
Excuse me, Your Honor, I will say that it wasn't Mr. Waxman's fault.
I'm used to being blamed, Your Honor. That's perfectly fine.
I wasn't even going to comment on that.
It's paragraph 11, Your Honor. There's a very small change. I can't read the black line on my iPhone, so I do apologize.
Okay, well, if this is agreed upon language and the U.S. trustee signs off on it, then I'm sure it will be acceptable to me.
We may want to make sure that the U.S. trustee has seen this language.
But
Your Honor, Hannah McCollum for the U.S. trustee. I have seen the language. I am not thrilled with this resolution, but as we have all agreed amongst ourselves, this is the first day hearing. This is not a final order.
Right.
It is fairly customary to give debtors who are not in compliance a period of time to do so. Mr. Waxman is discussing the matter with his client in terms of whether that bank is willing to sign a UDA. 345 allows the debtor, although my people have told me it's not actually the debtor that gets the bond, it would be the bank that gets a bond, but somebody gets a bond and protects it, because if you look at the cash management motion, it's between $7 and $8 million total in these debtor accounts. We're still not sure whether the money market accounts are like risk-bearing accounts that where money trades or anything like that, and that's another problem under 345. But I think it's very fair to let the debtors have a breathing spell. Let's see if we can get that resolved. If not, we can come in front of your Honor and say, no, there's no grounds for a 345 waiver, or the debtor presents their case and convinces your Honor that there is grounds. So, thank you.
Mr. Waxman?
Good afternoon, Your Honor. Jeff Waxman of Morris James on behalf of Community Banks of Colorado. My co-counsel, Morgan Lawrence, is on Zoom. We are working with the U.S. trustee to try to figure out where we go in terms of whether or not there will be a bond, UDA, and so we're asking for 30 days or alternatively 2 days after entry of the final order. The parties can certainly agree to extend that without order of the court. That's what the language is intended to do, and certainly we intend to work with the U.S. trustee's office.
Okay,
And of course the debtors.
very good.
Thank you.
Okay, well, I certainly think there should not be on the first day a disruption in the debtor's accounts, which it needs to be able to use in order to make payroll, for example. So, and then, pay insurance, et cetera. So, I will approve a form of order with revised language that has been circulated and agreed between the debtor, the bank, and the Office of the United States Trustee. And we'll deal with what happens after today when parties are able to discuss and see what the options are and and the debtor proposes what it wants to do on a final basis. So I will sign off on that as necessary to avoid immediate and irreparable harm.
We appreciate that, Your Honor.
Thank you, Your Honor.
Next on my list is payroll at docket 8. The relief I believe that we need and need to ask the court today is simply permission to make the last payroll cycle, which happened to end the day before the petition was filed. It is obviously necessary to keep employees, maintain morale. concern. What we have requested is authority to set forth in the proposed interim order on a not-to-exceed basis of $211,000. The order, I believe, also provides, and I could represent that, the payments to individuals cannot exceed the 507 caps. We did add, there was one comment, and I think this may have been the only comment to this motion from the United States trustee, asking that the order provide the debtors will not discontinue or reduce any compensation to employees without notice and an opportunity for hearing. We were agreeable to that. We had no thought of doing so anyway.
Okay,
If I may approach.
you may.
In paragraph 7 is the red line.
Thank you.
And Your Honor, if I would just offer my comment, I don't remember whether you were the judge in Cachet. Okay, that was a case where the debtors just terminated all of their benefits programs and did not provide any notice to their employees, and it caused an enormous amount of disruption and harm and bad feelings and all that. So I don't think the debtors are going to do this, but if they feel the need to reduce these benefit programs or eliminate them, especially because some of them have to do with subsidized housing and that sort of stuff, to please let the employees know sufficiently in advance that everybody can come to court if there's a reason to do so.
Okay.
So, thank you.
Thank you. We all learn from other cases. Yes, I saw the benefits that we don't always see in cases. I was curious about the property professionals lease that's discussed at page 12 of the motion. The debtor subleases a rental property to an employee.
Oh, I do have a recollection of this. Yeah, if I may.
Yes.
And it may be, so I don't get this wrong, I'll ask the CRO to join me at the podium if that's okay, Mr.
That's fine.
Maniscalco. Generally, Your Honor, and I think housing is very difficult in that part of in that region of Colorado, and housing for employees compensated at that level very hard. So what the company has done on a few is subsidize housing, for a dozen or for something at a time. And we want to be sure we're answering your precise question.
Your Honor, I believe Mike's depiction is accurate. The cavern, the housing costs are just out of control, and we have a wide range of employees to include hourly, people that are making between $18 and $22 an hour that cannot actually afford to live, to work at the park. In fact, staffing the park is a challenge. So what you see depicted here, these are forms of subsidized housing.
Right.
So it's coming through as a benefit.
And there are others for multiple employees. I think this one is for one. And I think
that
was
is
your
for one,
question.
and depicted in 39. That's the subsidized housing.
Yes.
And then depicted in item 40 there, again, that is the sublet of a rental property to an employee. So all related to the fact, again, that to attract and retain qualified employees for the park, housing is made available where possible. And
Oh, okay, I see.
Yep.
And the debtor here is paying the landlord $13.50 a month, and then it's subleasing that property to an employee for whatever percentage of that, or...
yes, Your Honor.
In taking it out of the paycheck.
Got it,
Yes, Your Honor.
got it, okay. Okay, thank you. Was really the only question I had with respect to the benefits that are being provided. Is there then a revised form of order on the employee wages and benefits motion?
I did. Did I hand it out? I think I
Did
handed
you give
it up.
me that one?
And that would be the one with paragraph 7 in the red line, though, but they won't be reduced.
Yes, here it is. Okay. Okay, does anyone wish to be heard with respect to the employee wages motion? I hear no one. I reviewed it. I've asked my question. I have no other questions. Obviously, the employees need to be, continue to be paid what they have earned. So I will grant this as necessary to avoid immediate and irreparable harm in the revised form per the comments from the Office of the United States Trustee.
Thank you, Your Honor. And I think the last one is cash collateral at docket number 9.
Your Honor, if I may, Bill Hazeltine again. We have the same issue with the cash collateral order that we had with the cash management order. So I'm going to hand up a black line, and then the one that we received this afternoon that doesn't show any black line.
Okay, thank you. Mr. Waxman can tell me what I need to look at. Thank you.
And Your Honor, subject to everyone making sure that they have their eyes on the same language and are agreeable to it, I think we're proceeding by consent here.
Yes.
We've had a good working relationship with the bank, both as lender and depository bank, which is part of the spiel I left out in terms of cash management. And there has been back and forth regarding a budget and what's needed to maintain operations at the park. There's a budget attached, and part of the proposed cash collateral order, and the bank and the debtor have worked together to negotiate the form of that. The form of order that is presented to Your Honor authorizes expenditures in the ordinary course of business needed to maintain normal operations pursuant to the budget, all of which are needed to avoid immediate and irreparable harm to the estate. I think, and this may be subject to a little bit tweaking in terms of clarifying language, but of course there's replacement liens offered as adequate protection. I should also note that this does have a challenge period, that structure, and in this case it is 75 days. The U.S. trustee did make some informal comments, and I believe all of them were accommodated in this, again, subject to the question of whatever the last second change was. And one of them relates to the fact that the lender is not an approved depository, so we had to address that again. Another was regarding the priority of the replacement liens, just ensuring that that was completely clear. Ensuring that the challenge period is 75 days. And then there was in paragraph 10 provision regarding termination of use of cash collateral upon a default and the permitted scope of hearing at that. And that has been changed.
Ms. McCollum knows my preference on that. Yes.
So on this one in particular, I want to be careful and open the floor to other parties because I think there was some language.
Yes. Mr. Waxman.
Good afternoon again, Your Honor. Jeff Waxman of Marsh Games on behalf of the lender. Your Honor, the one additional change that came in late that probably is not in the black line that was handed up originally is in paragraph 4B as in Bravo, which is replacement liens.
Okay.
I'm trying to figure out where that change is, and frankly, I'm just not able to see it on my BlackBerry compared to the black line. But I can tell you that the new language was subject and subordinate only to one, the carve out into the existing senior liens that are properly perfected or could be perfected under the bankruptcy code, but solely to the extent that such liens exist, are determined by the court to be senior to the lender's pre-petition security interest or liens, and without prejudice the right of any party to challenge such senior liens. And then there's additional language.
Okay, so replacement liens are not priming liens. if there is some senior lien,
Correct.
and they're subject to challenge.
Correct.
Okay.
And of course, this is, yeah, I'm not sure what the year change is. I think it's not like this. And of course, Your Honor, this is an interim order, so other issues may be addressed when it comes time for the final order.
And those changes are acceptable to the debtor, Your Honor, and just a little bit additional color. Probably the only type of lien we would be talking about here is accruing property tax, just in the ordinary course. The company has paid its trades, as it goes forward. We're unaware of any situation like a mechanics lien or anything like that. So the language here, it has to be right, but it is probably academic.
Okay. Let's see if I had any questions. On page 21, in paragraph 8F, I just think there was probably something carried over. So I see this is the challenge paragraph, and I see the change in the challenge period to 75 days, so that's great. And then here, there's a reference to if a trustee is appointed, what happens to the challenge period? And it says the trustee shall have until the later of 1, the expiration of the challenge period, or 2, the 30th calendar day, or the first business day thereafter if the 20th calendar day is on a Saturday. I assume those are supposed to be the same, and I don't know if it's 20 or 30, and which y'all landed on, but since you're going to fix the order,
Thank you.
we can fix that. Okay, so that was taken care of. The couple of changes that I had, Ms. McCollum has taken care of. So I've reviewed this. I've looked at the order. It seems to me a very straightforward consensual usage of cash collateral with no determinations being made by the court with respect to the collateral, including cash collateral, and with replacement liens and a super priority claim and no priming. So on those terms, and given the consensual use and the comments of the United States trustee having been taken and a budget being agreed upon, I will approve on an interim basis the use of cash collateral as set forth in the order and the budget.
Thank you.
And that will be approved. We'll look for a revised form of order, which has the language, the bank's new language, and whatever else we need.
Your Honor, Bill Hazeltine again. Would you you like us to upload the orders or submit them on their COC?
I guess I'd like to see the red line, particularly of the cash collateral order.
And cash management?
Yeah, and cash management.
Okay, so we'll submit those under COC and upload the rest.
And I think you can upload the rest because I've seen those, and you're just going to add the second day hearing date.
Thank you, Your Honor.
Okay. And let us know, in particular, when the cash collateral comes over. Shoot us an email because I know that's time sensitive and you need to get payroll paid.
Thank you.
Your Honor, if you can just say on the record that it's ordered subject to entry of the order, so there's no concern if the order doesn't get entered.
The cash collateral?
Yes.
The bank likes that, that's fine. It is so ordered.
Very happy
I
with
just
that.
want to make sure that we're not holding up anybody's paycheck.
I appreciate that, and I'm sure the debtor does.
We do indeed, and we appreciate the court's availability and opportunity to present these motions, and again, thank the other parties in interest.
Of course.
If there are no other questions, I think we're through.
I have no questions. Anything further for today? Ms. McCollum?
Your Honor, Hannah McCollum for the U.S. Trustee. I just wanted to let you know that the committee solicitation letters went out yesterday, and we are, it's the typical 1-week return period. We are also discussing the initial debtor interview timing and the timing of the Section 341 meeting with the debtors, and that seems to be proceeding apace. And there are no issues, and I really appreciate the debtors working with me as well. So
Okay.
thank you.
Very good. We're adjourned.
Thank you, Your Honor.